Welcome to Legalized Negligence, an advocacy podcast of one, where the mission is singular, the lawful, civil, and strategic repeal of Florida Statute Section 768.21(8). Today's episode tackles an overlooked, and likely controversial, aspect of that mission. One that, I suspect, will challenge the convictions of many who have spent years campaigning to abolish this law, investing their tears, time, and grief into the cause. At the close of Florida's 2023 legislative session, a bill was signed into law that fundamentally altered the state's tort landscape. I will walk you through the details shortly, but I must admit, its full impact didn't hit me until more than a year later. Following the 2024 session, I came across an article in a medical journal exploring how physicians were considering a path to challenge malpractice damage awards using the Equal Protection Clause of the 14th Amendment. The irony was not lost on me, doctors invoking constitutional principles to shield themselves, just as we were invoking the same challenges to dismantle subsection 8. At the time, I couldn't pursue the matter, so I offered it as a summer research project to a young woman, herself an outspoken advocate for the repeal of subsection 8. Unfortunately, she never followed through, and the theory sat idle. Until now. Fast forward to the closing hours of Florida's 2025 legislative session. Watching the heated exchange on the Senate floor over HB 6017, I saw all the pieces slowly fall into place. Suddenly, I understood why tort reform had been so aggressively pursued in 2023. I saw why damage caps dominated the repeal debate in 2024. And I realized why one particular senator kept returning to the negotiating table, offering the advocates a series of compromises, first $500,000, then $750,000, and finally a $1 million cap. Each offer was refused by the hardliners, the clean repeal or nothing crowd. That made no sense to me, as I will soon explain. So, enough with the introduction. Let's now take a dive deep into how a 2023 tort reform statute is inextricably linked to a failed attempt to repeal a medical malpractice exclusion in 2025. Strap in. This ride may take you places you'd rather not go. But by the end, you'll be forced to hold up a mirror and ask yourself a really difficult question. Do you actually believe in equality, fairness, and justice for all, or only when the scales tip in your favor? Let's begin.
Okay, let's jump right in. You've given us some really dense source material here looking at Florida's legal system, which seems to be constantly changing.
It certainly keeps things interesting.
So today we're doing a deep dive. The topic is Florida tort reform. Specifically, there's a pretty major change to how negligence works and what looks like a brand new legal theory popping up from analyzing these laws.
That's the plan.
Yeah.
We're going to try and, pull out the key information from these sources you sent over, highlight some of the more surprising connections between different laws, and really explore what this legal analysis is suggesting.
All to help you, the listener, get a handle on what's most important in all this.
Exactly.
All right, so let's start with the main event in these sources. Florida House Bill 837. It became law back in March 2023. What did it actually do? What's the core change?
Well, before HB 837, Florida had something called pure comparative negligence. The simple way to think about it is, even if you were mostly at fault for your own injury, say 99% at fault,
You could still get something back.
you could still recover 1% of your damages, yes. Your recovery was just reduced by whatever percentage of fault was assigned to you. HB 837 threw that system out.
Okay, so how does it work now under this new modified system?
So the new rule under HB 837 says the plaintiff, that's the person suing, they can only get damages if they're found 50% or less at fault.
50%. That's the magic number.
Right. And the sources give a really clear example. If you're, say, 40% at fault and your damages are $100,000, you can still recover $60,000. The total minus your 40%.
Makes sense.
But if that same person is found just 1 point over, 51% at fault, they get zero. Nothing.
Wow. Zero. That's a cliff edge, not a slope.
It really is. A massive difference based on a potentially very fine judgment call.
And this applies broadly, like car accidents, slip and falls.
Yes, the sources say it covers most standard negligence cases. Car accidents, if you slip in a store, product liability claims. It's the general rule now.
Okay, but here's where it gets complicated, according to materials. There's a huge exception baked in.
A very significant one. The sources really emphasize this. Claims involving medical malpractice are specifically excluded from this new rule.
So they stay on the old system.
Correct. Medical malpractice cases still operate under the old, pure comparative negligence standard, meaning, unlike the person in the car crash example, someone suing for medical malpractice can still recover damages even if they're found to be more than 50% responsible for their outcome.
Huh. So two sets of rules. Depends on who you're suing, essentially.
In a nutshell, yes.
And the sources mentioned this kicked in for lawsuits filed on or after March 24, 2023.
That's the effective date, yeah. Anything filed before that date still uses the old pure comparative rule.
Got it. So, okay, this law passes. What were the immediate reactions? What kind of potential problems did the analysts in these sources start flagging right away?
Well, the big one, jumping right out, is what the sources call differential treatment. Like you just said, two sets of rules. You've got general negligence plaintiffs facing this tough 51% bar, and then medical malpractice plaintiffs who don't.
And the worry is?
The worry highlighted in the sources is that this might not pass constitutional muster. Specifically, the Equal Protection Clause in the Florida Constitution. Does treating these two groups so differently have a solid, rational basis? Or is it arbitrary?
And beyond equal protection, were there other constitutional angles, like due process?
Absolutely. Due process concerns were raised too. Think about that plaintiff found 51% at fault. Losing your entire claim based on maybe a very slight difference in fault percentage. The sources suggest that could feel like a forfeiture of property, especially if figuring out that exact percentage isn't clear-cut. It raises questions about fundamental fairness.
Yeah, I can see that. It also seems like it changes what juries get to do, doesn't it?
It really does. That 51% cutoff kind of takes away the jury's flexibility in those really close cases, right? Their traditional job of weighing everything and deciding on a fair division of responsibility gets limited. The analysis frames this as potentially shrinking the public's direct role in the civil justice system.
Okay, and then the sources draw this line connecting HB 837 to another, older Florida law. Something about wrongful death, section 768.21, subsection 8.
Yes, that's a really key connection the analysis makes. Remember, medical malpractice cases are exempt from the 51% bar. They use pure comparative negligence. But Florida Statute 768.218 already puts limits on who can recover damages in certain wrongful death situations, like parents of adult children often can't recover damages in med-mal death cases.
So you've got two different rules interacting in a weird way.
Exactly, it gets messy. The sources argue that whether a family member can recover damages after a death could now bizarrely depend on both the fault percentage and whether the death was caused by a doctor versus, say, a negligent driver. It seems to create inconsistent outcomes for families based on factors that don't feel legally relevant.
And the sources also just question the number itself, right? Why 51%? Is there a logic to that number?
That question definitely comes up in the analysis. Was 51% based on some study or data showing it's the right place to draw the line? Or was it, kind of pulled out of a hat? Especially in really complex accidents or injuries, assigning fault isn't always precise math. So that hard cutoff can seem, well, arbitrary.
Okay, this is where the analysis in the sources really, for me, took an unexpected turn. It starts connecting all this back to older fights over that wrongful death statute, 768.218.
Right. The material digs into the history there. It reminds us of the arguments people used when they were trying to repeal 768.218.
What were those arguments?
The core arguments were about fairness and equality. Advocates argued that 768.218 violated due process and equal protection because it created this discriminated class. Certain family members couldn't sue for wrongful death just because of their relationship status, like being an adult child or an unmarried partner, regardless of how negligent the person causing the death was.
So the argument was basically, treat everyone the same, don't create special classes.
Exactly. Fundamental fairness, equal treatment under the law, no discrimination based on personal status. That was the thrust.
Okay, so here's the kicker in the source material. It poses this really sharp question. If those were the arguments used against 768.218, equal protection, due process, no special classes, why can't doctors now use the exact same arguments against the medical malpractice carve-out in the new law, HB 837?
It's a powerful point the analysis makes. It's like holding up a mirror. If plaintiffs argued it was unfair for them to be singled out based on their status,
as a certain type of survivor.
Right. Then why isn't it just as unfair for defendants, namely doctors, to be singled out based on their status as medical professionals? They don't get the protection of the 51% bar that other defendants now have.
It's arguing for a kind of symmetry, and the analysis pushes this symmetry idea even further, bringing up something pretty provocative about a patient's own health history.
Yeah, this is definitely one of the more controversial threads in the sources. It basically asks this question. If a patient has a bad outcome after medical treatment, but that outcome was significantly worsened, or maybe even mostly caused, by choices they made over decades, like smoking, obesity, not managing diabetes, ignoring medical advice.
Things the doctor didn't cause.
Right. Why should the doctor, who maybe made a mistake but didn't create that underlying vulnerability, potentially be on the hook for the entire catastrophic result? The sources do acknowledge things you can't control, like genetic conditions.
But for controllable lifestyle factors.
The question posed is, why shouldn't a doctor argue that the patient's long-term self-neglect is a form of comparative fault? Just like in a car accident case, if you weren't wearing a seatbelt, that can reduce your recovery because you contributed to your own injuries. Why not apply a similar logic in some medical cases?
This is definitely where the sources start constructing something new, a framework built from these connections.
Precisely. It starts by highlighting the lack of what it calls symmetry of claims in the system. Take equal protection. If the old statute, 7668.218, created a disfavored group of plaintiffs,
Certain survivors who couldn't sue.
then arguably the new carve-out in HB 837 creates an artificially protected group of plaintiffs, those suing doctors, who are exempt from the 51% bar. And conversely, it makes doctors a disfavored group of defendants because they don't get the same legal protection as, say, a negligent truck driver or store owner.
So the source asks, why treat medical defendants differently just because of their job?
That's the core question. And it ties into due process, too. Other defendants now have this clear 51% threshold potentially protecting them. Doctors. They're stuck under the old, less predictable system, possibly facing huge damages, even if only slightly at fault. The argument is that this inconsistency lacks the fairness and predictability due process should provide for everyone.
Which brings us back to that idea of contributory health negligence.
Right. The theory suggests maybe we should consider it. If a patient's actions in a car crash context, like texting while driving, contribute to their fault, why wouldn't decades of neglecting health potentially count as contributing fault when it drastically worsens a medical outcome?
The sources acknowledge the traditional eggshell skull rule, though. You take the plaintiff as you find them.
Yes, they mention that, and the difficulties proving causation is hard, plus policy reasons. But the analysis pushes back.
Asking that pointed question, if not wearing your seatbelt can zero out your claim at 51% fault, why shouldn't severe self-neglect matter when it turns a minor medical error into a disaster?
They use that hypothetical of a morbidly obese patient needing surgery. A small slip-up by the surgeon might have devastating consequences, mainly because of the patient's extreme underlying health issues, which are largely self-created or self-managed over time. The argument isn't to excuse the doctor's error, but to say the consequences shouldn't fall entirely on the doctor if the patient's own choices dramatically amplified the harm. It's about aligning the standards across different types of negligence.
And the sources find a kind of strategic irony in all this.
Yeah, it's pretty clever. The observation is that the very groups who fought against the old wrongful death statute, using arguments about universal treatment and no arbitrary distinctions.
They might have accidentally given doctors the perfect argument.
Exactly. By demanding equal treatment for plaintiffs based on principle, they inadvertently provided the same principled logic for defendants' doctors to demand equal treatment too, meaning they should also get the benefit of the 51% bar.
Wow. And the sources even frame this with a nod to philosophy, calling it the reverse Spooner idea.
It's inspired by Lysander Spooner, yeah, kind of flipping his ideas about justice. If Spooner might argue it's unjust to deny someone a remedy based on a status they didn't choose, like being an unmarried survivor under 768.218.
Then is it also unjust to hold someone liable for damages stemming from conditions they didn't cause or control?
Like the consequences of decades of a patient's poor health choices. That's the parallel the sources draw. It's proposing this kind of moral symmetry test. Is the law fair when you look at it from both sides of the lawsuit?
So, if we pull all these threads together, what exactly makes this whole line of argument, this new theory, novel, according to the source material?
Several things stand out. First, it's this idea of constitutional parity between plaintiffs and defendants, applying constitutional fairness standards like equal protection to how defendants are treated by the law, not just plaintiffs. It's not something you see argued very often.
Kind of flips the usual script.
It really does. Then there's the mere use of civil rights arguments, taking the logic used to fight discrimination against one group, survivors, and applying it to potential discrimination against another group, doctors under the carve-out.
And the idea of a preemptive accountability defense for physicians.
That's part of it, too. The suggestion that maybe long-term patient self-neglect should be formally recognized as a type of contributory fault. It's maybe a refinement of existing ideas about patient compliance, but framing it this broadly is new.
It also seems to view the impact on juries as a bigger problem.
Yes, jury disempowerment as structural harm. The analysis notes how both the old statute and the new one limit what juries can do, just in opposite ways. It suggests this legislative tendency to restrict jury discretion is a systemic issue.
So it's not just looking at one law, but the whole system.
Exactly. It's taking a systems theory approach, critiquing how these piecemeal changes, like the HB 837 carve-out, create these unbalanced, illogical systems. When you step back and look at the whole picture, who's protected, who isn't, and is there a rational basis for it all?
And this whole concept, this framework, the sources actually give it a name.
They do. They call it the reciprocal equity doctrine.
Reciprocal equity. And the core idea is?
As defined in the sources, it's basically this. Any legislative adjustment to liability must treat similarly situated parties, whether plaintiffs or defendants, with equal procedural and substantive fairness, or else violate constitutional principles. Fair is fair for everyone involved.
And the sources checked this isn't already a thing, this doctrine.
They mention running searches in legal databases. While related terms exist in other contexts, reciprocal equity doctrine, as described here, appears to be a novel formulation, emerging directly from this analysis of Florida law.
Okay, so it's a new idea. How do the sources suggest you'd actually use it? They bring up that old law school method, IRAC.
Yeah, issue, rule, application, conclusion. It shows how you could structure a legal challenge using this doctrine.
So the issue would be?
Does the law violate the Constitution specifically? Does it deny this reciprocal equity when it treats similar parties differently? Like the HB 837 medical carve-out does for defendants, or like 768.218 did for plaintiffs?
And the rule section, what laws or principles apply?
You'd lay out the established rules. Equal protection, probably using a rational basis test. Access to course principles. The standard for reviewing law is challenged on their face, de novo review. And then, crucially, you'd introduce and argue for the reciprocal equity principle itself, the need for structural fairness, consistency, unless there's a really strong system-wide reason for the difference.
Okay, then application, connecting those rules to these specific Florida laws.
Exactly. You'd argue HB 837's medical exemption creates unfairness based only on the defendant's job title, lacking broader justification. You'd argue 768.218 created unfairness based only on the plaintiff's personal status, unrelated to the defendant's actions. The sources contend both laws fail this reciprocal equity test because they apply standards unevenly, lack system-wide coherence, and basically play favorites based on status, not conduct.
Which leads to the conclusion
that, viewed through this reciprocal equity lens, both laws show fundamental structural problems. They're constitutionally suspect because they aren't fair across the board. It provides a new way to argue against them based on systemic balance and fairness.
It feels like the real core takeaway here, the refinement the sources emphasize, is that this isn't just about who was careless in one specific incident. It's about whether the laws themselves are fair in how they categorize people.
That's exactly it. The focus shifts from the facts of a case to the structure of the law. Is the law creating advantages or disadvantages based purely on who you are, your status, your job, your family situation, rather than on your actual conduct, your duties, or your level of fault?
And the sources crystallize this into a final definition for the reciprocal equity doctrine.
Yes. No individual, whether plaintiff or defendant, should be categorically advantaged or disadvantaged under civil law based on personal status, professional identity, or demographic classification unrelated to conduct, duty, or fault.
Simple but powerful.
And it brings the whole analysis full circle with that final question posed in the sources, tying the two statutes together again. Therefore, why should doctors be left unprotected from civil lawsuits by the carve-out created by HB 837 in the same way certain families were left unprotected against negligent doctors by the carve-out created by Florida Statute Section 768.218?
Highlighting that both carve-outs, though they seem like opposites on the surface, arguably commit the same kind of fundamental unfairness, treating people differently based on status, not substance.
Exactly. It's a critique of making laws in isolation without considering the overall fairness of the system.
Well, this has been quite the journey through these materials. We started with the big changes from HB 837 in Florida, the shift to modified comparative negligence, and that key medical malpractice exception. We saw the immediate concerns raised about fairness and equality.
Then we connected that to the long-standing debates around the Wrongful Death Act's limitations, Section 768.218.
And from there, we traced how the analysis in these sources builds this novel legal theory, the reciprocal equity doctrine, a way to argue for constitutional fairness that applies equally to plaintiffs and defendants, demanding that laws don't arbitrarily favor or disfavor people based simply on who they are.
It's a challenge to look at tort reform not just piece by piece, but as a whole system that needs internal consistency and fairness.
So maybe here's a final thought, something for you to chew on based on everything we've discussed from these sources. If our laws start treating people differently, not because of what they did, but because of who they are, their job, their family status, whatever, can that system truly deliver justice? Or does real fairness demand that we reform the whole system to ensure the rules apply equally, whether you're the one bringing the lawsuit or the one defending against it?